People call my office thinking they got a slam dunk win for getting custody of their kid because the child wants to live with them. I'm listening to that and go, uh-oh, we could be in trouble. You're probably going to lose at a hearing. Let's talk about how to avoid losing your custody case when your kid does want to live with you. I'm Jim Cravell, lead attorney at Cravell Family Law. When your child tells you that they want to live with you, let's assume they've got a really good reason. Will the judge order a change of custody? How do you go about changing custody? By the end of this video, you'll have a clear understanding of how Michigan courts apply the reasonable preference of the child. You'll know what factors influence the court's decision, and you can use this information to your advantage. Let's dive in. When Michigan courts make a decision about custody, they have to apply a standard set of factors laid out in the Michigan Child Custody Act. That's specifically Michigan Compiled Laws 722.23. Factor I, or the reasonable preference of the child, is one of these factors. It's designed to give weight to the child's opinion, especially as the child matures and becomes capable of expressing a preference about where and with whom they want to live. But the key word here is reasonable. The child's preference isn't just any opinion. It's got to be reasonable. And it'll take into account their age, maturity, the overall circumstances. In other words, the court doesn't walk up to a 10-year-old and say, "Where do you want to live?" and then make a decision based solely on that answer. The court is also going to consider how well the child understands their decision, the reasons behind their preference, and whether or not that preference actually aligns with their best interest. Let's break this down a little bit further. First, factor I doesn't give children an outright veto over custody decisions. Courts retain broad discretion in custody cases, and the child's preference is just one of many factors that the judge has to consider. For example, a 6-year-old's preference is probably not going to carry as much weight as a 16-year-old's preference. The older and more mature the child, the more significant their preference becomes. So you might be wondering, what does the court look at when determining whether a child's preference is reasonable? Well, it's not just simply listening to their wish. They have to look at several elements. First, of course, the age and maturity of the child. A younger child might not have the emotional or intellectual capacity to understand the implications of their choice. Courts are more likely to consider a teenager's opinion as reasonable because they usually can articulate their reasons more clearly. The reasons behind the child's preference might be caused by different things. Is the child simply picking the parent that they think will let them stay up late? Or is there a deeper emotional connection to one parent over the other? If the child's reason is based on avoiding conflict, that might not be seen as a reasonable preference. Courts are looking for thoughtful, substantive reasons. The child's ability to express their preference without undue influence is another issue. Courts will consider whether or not the child's preference has been influenced by either parent in any unhealthy way. I had a case once where the child came in and said, "Well, Daddy said if I answered this way, I was going to be getting a pony." Well, the investigator who was listening to them realized that that was not a good reason, and so their preference wasn't reasonable. If one parent's trying to manipulate the child into choosing them, the court's going to probably find out, and they're going to scrutinize that. For example, in Meyer v. Meyer, there's a Court of Appeals case where they looked at a child's preference, and they ended up giving the trial court guidance that says when the preference is reasonable. In that case, the child had just turned 10, so we're not dealing with a 5 or 6-year-old. And unfortunately, in that case, back then, the trial court didn't interview the child because the court thought or believed that the child could not make a reasonable preference. They said, well, that's because of his fragile mental state and because the child was being coached by a parent. Those were legitimate reasons according to the Court of Appeals then. Since then, there's a new case that says the court has to take the child's preference in every case. I think it's from age 5 or 6 on up. But in that case, it was a legitimate reason. So it's not just simply about age or maturity, but the court's going to look at the totality of the circumstances surrounding the custody dispute. So again, does the child's preference fit within the context of all the other factors listed in MCL 722.23? For example, if the child's preference is to live with one parent, but a review of the other factors would indicate that that parent's going to cause emotional harm or disrupt the child's education, court's probably going to deem that the preference is unreasonable despite the child's stated wish. So the judge doesn't just look at the kid's preference in isolation. It's weighed against all the other best interest factors. And ultimately, the court has the discretion to give more or less weight to the child's preference based on the child's maturity, the reasons for the preference, and all of the other factors involved. Now, as a parent, you might be thinking, well, what can I do to influence my child's preference in a way that's going to help me? First and foremost, you should avoid any attempts to manipulate or unduly influence your child. That's only going to backfire. Instead, focus on building a strong, supportive relationship with your child, fostering an environment where they feel comfortable expressing their feelings and their opinions. You're going to also want to avoid talking negatively about the other parent in front of your child. Negative comments can alienate the child from the other parent, and courts see this as parental alienation, which can damage your credibility in a custody proceeding. So, the bottom line, I often see parents file a motion to change custody when they hear that their child wants to live with them. The parent forgets that the court's going to look at the 10 other best interest factors. And so the court is going to look at all of them and weigh all of them. And so failing to ignore all the facts that apply to all the factors is going to hurt your child custody case. No matter your child's age, the court's going to always look at all the factors. So, in conclusion, while factor I gives weight to the reasonable preference of the child, it's not the deciding factor in a custody dispute. Courts are going to look at the whole picture. They're going to look at all of the best interest factors. If you're involved in a custody dispute, understanding how that reasonable preference of the child is evaluated is essential to developing your strategy. Remember, courts are looking for a well-reasoned decision that prioritizes your child's well-being and stability. If you can demonstrate that your child's preference is grounded in sound reasoning and that it aligns with what is truly in their best interest, you'll have a stronger position. Thank you for watching today's video. If you have any questions about your specific case or need help navigating the complexities of custody law in Michigan, give my team a call. Until next time.